Hello, I'm attorney Dan Marr from the National New Hampshire law firm of Hamilton Carrigan. I've been practicing law in New Hampshire for about 39 years and in the Commonwealth of Massachusetts for about 29 years. I'm going to be focusing today on our New Hampshire Consumer Protection Act. It's called RSA 358A, and it applies equally to business disputes. And that's what I'm going to be focusing in on today. Even though it's called Consumer Protection Act, it's protecting also consumers of businesses that are consumers. There's a lot of laws out there that are just meant to protect purely somebody's buying household goods or consumers of cars and the like. Like there's debt collection practice act that only applies to consumers, but the New Hampshire Consumer Protection Act deals with not only those issues of business to a consumer, but also business to business. I'm going to focus on that. The New Hampshire Consumer Protection Act, RSA 358A, provides that certain things are not allowed. They're unfair and deceptive trade practices. And if you have an unfair and deceptive trade practice within the definition of the Consumer Protection Act, and you're a victim of that, you can bring a claim against them, and you can get up to, depending on how willful the violation is, you can get up to double or triple the damages, so 3 times the damages that you actually suffered. There can be some statutory penalties of just per situation of a certain flat amount that you can get for damages. So if you're not hurt a lot, you can get those. But usually for businesses, you're dealing with your actual damages. And if you can get double or triple of them, that's significant. Plus, you can get your attorney's fees, where often in contracts, if you don't have a attorney fee provision, New Hampshire doesn't allow you to get attorney's fees. You have to have special exceptions for that, and the Consumer Protection Act is one of those exceptions. So this deals with issues. They define what unfair deceptive trade practices are: passing off the goods as or services as those of another. You're saying that's for this higher level company that's doing it, but you're actually having somebody else do the work. That can possibly be a violation of the Consumer Protection Act if you're getting lower quality people doing this stuff and they're not being told that. Misrepresenting the source of the geographic origin or the sponsor of the goods. So if you're saying that these goods are something higher quality, a different brand than what they are, they're a lower quality brand, then that could be a misrepresentation. Advertising something with the goods or services without the intent to sell them that way. So you're saying you're willing to do something at this price when you have no intention of doing it at that price. When they come in or they hook you in, you're going to do what they call a bait and switch. And you have somebody else do it. You don't have enough of those goods, or you don't have the people to deal with those services, but you rope in that person and then you convince them to buy something else. That bait and switch can be a Consumer Protection Act issue. Usually business to business, that part is not as much because people are sophisticated business people know enough about it. But these situations where the goods are sold or the services are provided and they're of less quality and you're making misrepresentations, that can be a level. There's also something in the business to business arena when we're dealing with a business dispute. Often it doesn't fit into those categories. There's a whole list of categories of consumer protection violations. You might not fit into that, but does it fit into unfair and deceptive trade practices? People in businesses often are saying when somebody's breaching a contract that it's an unfair and deceptive trade practice. Look, they didn't give what they said they were supposed to do. Not enough. It has to meet what they call the rascality test. What rascality test is, for those who are in the rough and tumbly world of the business, they're shocked by this. And that takes a lot. And it is overly pled in lawsuits. Overly pled meaning that people will often make a claim when there's just a regular business dispute between the two businesses. They'll throw in what they call a consumer protection claim, and it's not going to meet it, but it's kind of a shock and awe for the lawyers are trying to do the other side, saying, oh, wait a minute, we maybe get our attorney's fees and double or triple damages, when it really is a fight over whether or not they produced the product that they were supposed to produce, or was there something that happened that they couldn't produce the product, and what's the actual damages. In those situations, even though they make that allegation of consumer protection claim, they're not going to be successful in that because it doesn't meet the rascality test in regards to that. So these are things that you sometimes see in a lawsuit, that somebody might do a shock and awe on the claim that you have against you, and it's just a breach of contract claim, but they're adding this claim and they're trying to shock you into, oh my God, you have the tiger by the tail, you're in real trouble. It's not necessary. If there are situations where somebody's committed fraud to you, they've gotten you into goods and services in your business, and they've duped you, really duped you, consider the Consumer Protection Act. I've had those claims that I've dealt with fraud cases, and they're meaningful, and they can add a lot of a different element to the exposure of the other side that committed the fraud. They're not just having to pay you back for what you're damaged, but they could get up to trouble the damages, meaning 3 times the damages, or and attorney's fees. Significant. I'm attorney Dan Ma. I've been practicing here at Nashville, and I've dealt with a lot of these consumer protection claims and other business-to-business disputes. Happy to help you if the opportunity arises. I'm at 603-883-5501, 603-883-5501. You can also check out my weekly vlogs. Go to nashvillelaw.com and go to my bio and click my YouTube channel. I do weekly vlogs all identified by topic, and happy to help you if the opportunity arises. Thank you.